Are you one of the 67% of Americans who are leaving what happens to you and your assets in the event of a disability or death up to someone else, including the state? If you don't have anything put in place, then your loved ones could be in for a long and expensive battle with the legal system just to prove what they think you would have wanted. People often mistakenly assume that you have to have a lot of money to justify drafting a will or creating a trust, which just isn't true. These are tools in an estate planner's toolbox to make sure that your wishes are followed through with. If you're concerned about incapacity or want to make sure that your assets transfer to beneficiaries in a particular manner, it's really important to make sure that you have something put in place. I'm Amber Knips, a wealth advisor at Sweet Financial Partners located in Fairmont and Jackson, Minnesota. And I specialize in working with high net worth individuals as they navigate life's biggest transitions, both expected and unexpected. We believe that everyone has the right to realize that their dreams are possible, and we use that as a focus when working with clients and helping them plan for their future. A question that I get asked a lot is, are there any disadvantages to trusts? And I wouldn't necessarily say a disadvantage, it's more of a trade-off. A trust can be more expensive and more complicated than a will. Sitting down with an estate planning attorney can be expensive if you don't know what you're looking for or what you want. You could end up paying thousands of dollars just to talk through your situation, not including the cost to actually draft the documents. But something really important to consider is incurring some of those extra costs on the front end could end up saving your loved ones a significant amount of money on the back end by avoiding probate. So at Sweet Financial, we don't provide any tax or legal advice. However, we do aim to talk our clients through some of those considerations in advance through our Dream Architect planning process. So we try and provide insights and considerations to help have a successful meeting when you do sit down with your estate planning attorney. So working through some of those details ahead of time could potentially save you money in the long run too when you do finally have that meeting. For most people, estate planning usually starts with a will at kind of the most basic level, which deals with not only where you want your property to go, but also who you'd maybe want to care for any minor children, if you have any, in the event that both parents are deceased. There are several estate planning techniques that we do for all of our clients, such as adding beneficiaries to any retirement accounts and adding transfer on death designations to any after-tax accounts. So what this does is when you pass away, your assets avoid probate and they're transferred directly to the listed beneficiaries. Once the beneficiary receives those proceeds, they can do with them as they wish. So if having your assets distributed all at once to a beneficiary makes you a little uncomfortable, maybe a little itchy, then it could be a reason to think about doing some deeper planning and maybe considering a trust. A question I've been getting a lot lately is, do I need a trust? Which is then usually followed up with, what is a trust anyway? So starting with the basics, a trust is an agreement that specifies how your assets are to be distributed, and usually with the involvement of no probate court. So this can be structured to take effect before death, after death, or in the case that there's incapacitation. So you might be thinking to yourself, well, gosh, doesn't that sound a lot like a will? But, who gets things upon your passing? But one of the major limitations of a will is that you have to die first. If you're incapacitated, a will has no legal effect, which is why it's often important to have healthcare and durable power of attorneys put in place so that they can help guide some of those decisions if that were to happen as well. Trust can be arranged in a variety of different ways to achieve a lot of different goals, and a big benefit of a trust is control. So it allows you to say how much, how often, to whom assets are distributed, so much more specific than a traditional will allows. And on top of that, there's a lot of different types of special use trusts that you can establish to accomplish a lot of different things, like maybe estate planning goals, charitable giving, tax reduction, and more. So taxes might be especially top of mind lately as there's continuous talks on the gift tax exemption and what that will look like. That's a topic for a different day. What I'm going to focus on today is questions that you can be asking now to start determining Does a trust make sense? Does a will make sense? What does that look like for you? And specifically focusing on, do you need a trust? So the first question to ask yourself is, would you like to provide assets to beneficiaries while you're still alive? If the answer is yes, then you may want to consider a trust. Trust can be set up to take effect before or after death, or if you're incapacitated. If you're like, nope, I just want everything to pass when I'm not here anymore, then maybe just a will is sufficient. Another question to ask yourself is, would you like to make plans for your assets eventually, but still maintain control over them while you're alive? So if the answer is yes, perhaps you'd like a child to benefit from your estate, but you're worried about their ability to manage the assets. A trust is going to give you a little bit more control. So you can set terms and conditions on how that money is managed and used. And something like a revocable living trust would allow you to have some of that control, but you can still move money in and out. So you're maintaining that control as you wish. If you're like, gosh, no, I just want everything to be pretty simple, a will may be sufficient. So taking this a step further is, if you'd like to place specific conditions on the funds, then it may make sense to consider a trust and seeing if that makes sense for you. So an example of this could be, maybe you want the beneficiary to receive a third of the funds when they're age 30, a third at age 35, a third at age 40. Or another clause would be they can't have any funds unless they have stable employment, or you can only pay out funds for specific purposes. Trust can be especially important with second marriages, where maybe one spouse wants to leave assets to their biological children and not their stepchildren. Maybe they want to leave a large account balance to their spouse to use and live on during their lifetime, but after their passing, they want the remaining assets to go to their biological children. This would allow you to have the control to do that. If you just leave the account outright to a spouse, then they can turn around and change beneficiaries to anyone that they wish, which maybe don't follow your wishes. Another question to ask yourself is, will your estate be subject to very high taxes? If the answer is yes, some trusts may help you to minimize estate taxes and offer beneficiaries some protection against maybe some creditors. An example of this would be assets are placed in an irrevocable trust, and those are generally then removed from your estate, which helps to reduce your overall taxable estate. Gifting over time can help with this as well. There's a bunch of nuances to consider, but that's at least a great starting point to get an idea of if you fall into that category. The current estate tax exemption is over $12 million from a federal standpoint. So that gives you kind of a rough starting point. Something to keep in mind is that although that estate tax exemption is high right now, that might not always be the case, as well as each state has different rulings for their specific state. So oftentimes they're much lower. So that's something important to keep in mind, as well as account growth over the lifetime. How do those projections look, when you're taking into account things coming out of the account or maybe inheritances down the road? A lot of our clients tend to not spend down their accounts due to some of the adequate cash planning that we've done. You'll also want to take into account growth over the lifetime. So look at how those projections look after doing things like gifting, maybe further inheritances that you'll receive down the road. A majority of our clients end up not spending down their accounts just due to the adequate cash flow planning that we've done. So moral of the story is, don't necessarily count yourself out because that number seems high. It's worth running some of those projections. Another question to ask yourself is your estate very complex? So if that's a yes, if you have quite a bit to plan for, such as children from previous marriages, maybe special needs children, second homes, if you have very large assets, it gives you some of that flexibility to define limitations for some of those beneficiaries. So you can exactly specify which percentages would go which way. An example of this is that I had someone who wanted to leave 25% to each of their children, but they had specific feelings on what they would want to happen if that child were to pass away. They didn't want that to get split between the surviving children. They wanted that share to go to a beneficiary. So in this case, it's worth evaluating to see, does a trust make sense? If you just have traditional assets such as a car, your main home, retirement accounts that already have beneficiaries on them, a will might be sufficient. Something to consider is that some states allow for transfer on death deeds on real estate and vehicles. So that gives you the ability to do even more planning with a relatively simple tool and be quite cost efficient. Another question is, do you have minor children? And if the answer is yes, maybe look at some of that deeper planning to see if a trust makes sense. Because if you're going to need to specify a legal guardian for the child, you're also going to need to specify who's going to be in charge of the funds. Since minors can't own assets outright, you'd want to make sure those assets are protected and that someone's not going to be frivolous with those funds. Oftentimes we recommend those being two different people, just the one who's in charge of the funds and the actual legal guardian, just to help reduce any conflict of interest and help ensure that funds are preserved for the beneficiaries. If not, and you're comfortable with your children receiving or your beneficiaries receiving everything all at once, then might not be needed. Do you have any special needs beneficiaries? And we touched on this a little bit, but if you have anyone who maybe requires some extra special care, setting up a special needs trust might make sense so that any funds that they receive do not interfere with any governmental benefits or disability benefits that they're currently receiving. So speaking with an estate planning attorney on that individual situation and what level of care they need, they can kind of go through and figure out the best situation that works for you with your intentions. Are you worried about your ability to manage assets if you become ill or disabled? If the answer is yes, if you're concerned about dementia, something like that, a trust can help you establish clear authority now when you're able to do so effectively versus when you're unable to do so in the future. Something with this too is other elements of an estate plan, such as power of attorney, that can also help loved ones make that decision. So taking this kind of consideration a step farther is things like elder abuse, romance scams, credit card scams, those are on the rise. And oftentimes, unfortunately, elderly individuals are targeted, coerced, tricked into changing beneficiaries, maybe when they're in the hospital or under hospice care. So if someone is able to sign a signature or sign a form and get that signature on file, depending on who they're working with and where they're working with, if there's no immediate family to kind of catch it and their signature matches, that will get updated. So the good thing is we have really close relationships with our clients. We ask a lot of questions. And I always say, I'm gonna prim and prod because I want to make sure you're taken care of. And, we can help be that front line of defense to make sure bad things don't happen. But unfortunately, it's not always the case, depending on what the current relationship is with your advisor or if there's not an advisor on the account. So updating a beneficiary is pretty easy. That can get updated pretty quickly. It's a lot harder to go through updating an entire trust, which requires the help of an attorney. So that's another line of defense to say something maybe doesn't quite seem right. Take some extra steps to take care of. Another question is, would you like your estate to benefit of charity? And if yes, a special use trust can really help you achieve those gift giving goals. There's a lot of really great opportunities there. If no, and you kind of give on the side, maybe through your qualified charitable distribution, different things like that, a will may be sufficient if you're giving, maybe sporadic, smaller gifts to your favorite charities. If you are someone who's charitably inclined, I would recommend that you check out this video by Oliver Kolosky in our office. He goes over some really great strategies to consider to help maximize your gifts to charity. It's a really great listen. So really overall, this only scratches the surface. Again, not meant to be legal advice or tax advice, just to help guide you with that conversation as you start thinking, I wonder if a trust maybe makes sense for me. There's no black and white answer on yes or no. It really depends on your overall wishes and the different ways that you've created your wealth. So to continue the conversation, I do have a link below to help guide you through a little bit of that conversation to consider when you're reviewing your beneficiaries, and let us know how we can help guide you through that conversation to find out what makes the most sense for you.